heard a few of the reliefs that the suspended Chief Justice is seeking in this interlocutory injunction. And also, we're getting to know as well that for this interlocutory injunction, it is the former Attorney General, Godfrey Yeboah-Dame, who is her lawyer as well. How does all of this play out for you?
I'm totally surprised, and I'm shocked. I mean, to be very candid with you, shocked because, look, number one, I don't know why of all the lawyers this world, the Chief Justice went for Godfrey Dame. Godfrey Dame, who was caught on the Japati, being engaged in very unethical conduct, and you see that this is the person the Chief Justice is choosing, then you are like, oh, maybe, you see, I mean, the optics, it's not everything I can say, but the moment you draw that linkage, you see that, we are in trouble. Yeah, we are in extreme trouble. Then you begin to ask that, okay, so is this part of the reason why Godfrey Dame never got sanctioned in the first place? You see, so people can draw all manner of legitimate questions from this alliance. Yeah. It's very tacky. Very tacky. It's a difficult situation. Because Godfrey Dame was very unethical in the Japati. He was coaching a witness, suborning a witness, all those things. And then you find the Chief Justice go for Godfrey Dame. They're like, okay, now you would understand certain things. Look, Mr. Counsel, this is not the last you see of this alliance. You're going to see a lot more things that will be very, unpalatable. Yes. Trust me, in this nation, we sit here, you can see certain things. It's terrible. It's really terrible. Yeah, to be very honest. But look, if we don't speak the truth, we will not get far. I mean, come on. This is a guy who has an ethics case, a very serious one at that, on his head. And you say he should come and lead the charges. And he was Attorney General. You see, in the Speaker case, there were issues. People had raised many questions. So this link begins to answer some of those questions. So it's really a serious matter. Yes, it's really serious. I'm shocked. I mean, to be very honest, I'm shocked. You say so, but well, it's a democracy. Somebody say, well, the General Legal Counsel has not dealt with the case yet, and so we cannot draw conclusions. Yes, fair enough. Yes, the General Legal Counsel hasn't gone into it, but there are also certain situations where you always need the Caesar's wife's test. Live beyond reproach. You see, there are certain things you should do that will be said that they shouldn't draw suspicions. That's a key thing. Don't do certain things to draw suspicions, especially as you knew, as there were already suspicions when the Speaker matter came. Yes, there are suspicions. They are not, somebody will tell you that a multitude of suspicions do not constitute proof. Yes. So, taking Godfrey Dame as a lawyer in this case, for me, it does a lot of damage to the Chief Justice case. It does a lot of damage, at least in the court of public opinion. And a lot of the time, public opinion is very important. The optics are very, very important. The optics even go well ahead of the substantive decision. But let's see how it goes.
Right.
But they have a right to also approach the court. By all means, you see that to the extent that they've gone to court, they will be able to demonstrate to you that their case is a bit different from the Kofi Korte case that was just dismissed today. So, yes, that's one thing you are bound to find. Right. I mean, this is the work we do. Once you find a lawyer saying, I'll go to court, then he's trying to say that his case is different from the precedent, as I had mentioned earlier.
Indeed, but just to make the point that no two cases are the same, no matter how similar the reliefs are, as we have referenced. But, Counsel, earlier you made the point that, in your view, the suspended Chief Justice should have resigned by now to, as it were, save us all this process going all the way down to the wire. But it is well within her right, is it not, for her to go on this path of exercising that particular right of going to court, seeking this interlocutory injunction and all the reliefs in there, isn't it?
Oh, yes, yes, yes. It's within her right to go on. The Constitution allows that if a person is not happy, okay, with a decision, you can approach the court. You always have the right, all right? And even in the Constitution itself, you see that in Article 125, they'll tell you that justice emanates from the people. Yes, right now the acting CJ is no longer, the suspended CJ is not in office as a CJ. So more or less, if we say justice emanates from the people, she'll be counted among. Even when she was sitting as Chief Justice, when we say justice emanates from the people, she would also be counted, notwithstanding that she also wears another cap, or she wore another cap as CJ. So it's well within her right to go to court, okay? Yes. The only problem I have, and that's quite significant, is that because of who she was, right now she's suspended, you know that a case concerning her will attract a lot of public interest. And as the public scrutinizes the case, it's the, long term, it's the judiciary that will come up short because, as I mentioned earlier on, for a lot of people, they engage in conspiracy theories and they are okay because they will tell you that you will never find the truth. So whatever your eyes see is a truth. Don't mind that somebody can come later and prove something otherwise. So with these accusations, counter accusations, the judiciary is losing face. The judiciary is losing, apparently, even if not real, there is a loss of confidence because it will be like, oh, so the judges can't deal with their own matters. Do we have to wash? Do they have to wash their dirty linen in public, etc.? There are so many things that will go against the judiciary, and also against. When we say judiciary, and by extension, the legal system. And so lawyers, we are also affected because lay people will reach out to us that hey, you guys, what's happening to you? Because they count us together with the judges, etc. Right? So there'll be some kind of loss of confidence. Even though the other side too is that the more citizens question the justice system and express their opinions, we are likely to get reforms. We are likely to find the justice system more responsive. But as I said, for me, for now, it appears that the damage is more because where we need citizens to weigh in and to contribute more is about reforming the justice system, getting a modern justice system. Our justice system is outdated. Okay, it's not modern enough, right? In terms of the trial, procedures, right? The substantive law. There are a lot of things that have changed. Okay, we used to copy a lot from the English people. Yeah. Now there is a wide gap between us and them. We are not catching up. So those are the weightier issues, right, that we expect that if citizens should weigh in, that's the direction we need more help, rather than matters of disciplinary issues concerning judges. So that's how come I would have wished that the Chief Justice would go by the biblical edict in saying that everything is permissible for me, but not everything is beneficial. Yes, Mr. Okanse. In 1 Corinthians 6-12, the Bible says that everything is permissible for me, but not everything is beneficial. So in this case, yes, the Chief Justice has a right to go to court. But if you look at what the whole justice system is suffering, the unnecessary scrutiny at this time, you see, it would have been better that the Chief Justice resigned so that the system can, quickly try to heal and then, we make progress.
Well, but you also acknowledge as well in that earlier position that, yes, it is within a right to want to go the long haul down to the wire to see how this process would end full scale. But then, counsel, stay with me, and then we'll also hear from Kwansa Sari, former director of the Ghana School of Law, in a bit. Because apart from the two reliefs that Dennis highlighted earlier, there are a few more reliefs that her leadership, Justice Gertrude Torkornoo, is asking in this interlocutory injunction. Dennis, what do we know?
Well, so the three reliefs that I just did a while ago, those relate to the interlocutory injunction. Now, what we are about seeing are reliefs that are being sought in the substantive matter. So these that you would see, which involve some of the things that we may be hearing for the first time, because there haven't been things of public record, are indicated in this, which is in the substantive matter. So the first relief, she basically wants a declaration to the extent that she has a right to a public hearing. So she cites the provisions of the Constitution that relate to everybody being equal before the law, the right to fair trial, and also the provisions that relate to the constitution of the committee and its work, commission of inquiry, and then the exercise of discretionary powers. Then there's a part where she now says that she wants a declaration that the Chief Justice can waive the in-camera nature of the proceedings under Article 146. Mind you, we have said on this show, time without number, that the whole proceeding is supposed to be in-camera.
Absolutely.
But she is saying that she wants a declaration that the Chief Justice has the right to waive that particular right that she has. I mean, or the nature of the proceedings.
I see.
Is that to suggest that there's been a request for such to be waived? We don't know.
Well,
we're only seeing this.
Because we had read some media reports that
Yes,
she had
that seemed to suggest.
requested that, you know, this in-camera one be put away. She wanted it telecast for us all to see the hearings of this 5-member committee. From the communication last week.
But that is supposed to be in camera.
Absolutely. From the communication last week,
yes,
this 5-member committee's hearings have begun.
Precisely so. And they are ongoing.
And they're ongoing. And this, she's asking that she wants that right that she has as an accused person in this particular case.
She wants a declaration to be made that that right can be waived.
So then we would all see.
Yes.
The committee is here.
That it can be waived so that she has the option to waive or not to waive. Or anyone, not just her, but that anyone who is in that situation would have the option to waive or to stick to what the Constitution provides. And that she wants a declaration in that regard.
I see. But then what does the 146 state in dictate? The specific detail of in there. Does it give in this case, the suspended Chief Justice that leeway or the right to ask that this particular in-camera hearing within her right be waived?
Mind you, she came from a number of provisions. So when you look at all these provisions and what they provide for.
17.1.
17.1, equality before the law. 19, the whole of 19 is on fair trial. 1, 4, 6, 7, and 8. These are the matters we've been talking about, the committee and its work. 281, commission of inquiry and how they should conduct their business and how the proceedings should go. 295 and all. So when you look at it, now she comes to a point where she says that make a declaration that after all these things, it should be possible that somebody who comes to these proceedings, even though the requirement is that it should be in camera, you should have the right to waive that. That is a matter entirely for the Supreme Court to make a determination on. Whether they agree or they do not agree, it's a different matter altogether. And these are matters that will be determined in the substantive suit.
Well, let's stay on this. And Kpebu, what's your own position on this? What's your reading of this particular relief that the Chief Justice, that's her ladyship, Torkornoo, is asking in this particular one that Dennis just referenced about the in-camera hearing, and she asking that that be waived in her right?
Yeah, you know, lots of people have asked that, yes, the proceedings be undertaken or done in public. Yes, I agree because it helps. Justice is not a cloistered virtue. We don't do justice generally in secret, except in very grave circumstances, right? When there are extreme national security concerns. Please, extreme, not just any small thing that you waive national security. No. This one, I don't see what's the secrecy that it should bring. We should have it in public. So the rights, if you look at it, yes, we can't totally say that it's her right. Part of it, because it's constitutional, we need to exercise some introspection and also look at the provision well. So we are looking at Article 146 clause, I think 8. If I can get my Constitution. Yes, it says that all proceedings, it's either 8 or 9. That's Article 146. Okay, subclause 8 or 9. So all proceedings, yeah, should be held in camera. So the way it's been done, it's not totally stated as a right belonging to the Chief Justice. It goes beyond the Chief Justice. It's that's the person who is facing the accusations. It's also for the system. So the point I'm making is that her waiving her right to an in-camera hearing does not automatically mean that the committee is bound to grant a public hearing. No, that provision also covers the society as a whole, the governance architecture. So we would implore the 5-member committee to look at it and move. You can see that citizens have moved ahead of the Constitution and want to see it play out. So that one is an appeal. So the argument we must be very clear about is that the fact that the Chief Justice is waiving her right to an in-camera hearing doesn't mean automatically that the committee would accede to it. The holding of the proceedings in camera, that's in secret, all right, is not meant to protect only the person answering the accusations. That is to say, in this case, the Chief Justice, but it's also for the system as a collective. So it's for the committee to look at it. Maybe they may even say that, okay, then they want the Supreme Court to deal with that matter, that aspect of it, and then they can be guided. But it doesn't mean also that the 5-member committee must stop the hearing. We've already addressed the question of an injunction. That injunctions are not granted in such cases lightly. So the proceedings can continue, and if it turns out that the Supreme Court is willing to give an answer on the in-camera hearing quickly, when it is done, then we'll catch up with them. That is to say, the proceedings will then be telecast live from the date the Supreme Court accedes to such a request. That's if only the Supreme Court agrees that, look, they can interpret it to say that the proceedings should be done in public. But Mr. Kansi, once again, I must say that that's a tall order. If, to be frank, it looks to me easier that we will make it a public hearing in the next Constitution than to do an interpretation of this current one to say that it means you can also do it public.